Okay. Sure. So for the executive session consent calendar, we are going to be considering item number 1 separately and pulling that off of the consent calendar. The respondent is present but does not wish to speak, so we'll just be considering that agenda item separately. Does that mean we need to hear a report on that? No, we're just going to vote on that separately.
Yes, so that is simply a complaint that was filed that did not include documentation of the grievance process. Therefore, the commission needs to dismiss.
Okay, so we just need a motion to dismiss that one separately.
Right.
Okay, so Vice Chair, can I get a motion on executive session consent calendar item number 1?
Thank you, Madam Chair. I move the case against Kevin Moss be dismissed.
Okay, commissioners, you've heard the motion as to executive session consent calendar agenda item 1, Kevin Moss. Administrator, can you please call the roll?
Commissioner Jancy,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Burke,
Aye.
Commissioner Mettler,
Aye.
Commissioner Thompson,
Aye.
Commissioner Helt,
Aye.
Chair Payne.
Aye.
Motion passed 7-0.
All right, we're moving to hear the rest of the consent calendar, executive session agenda items 2 through 4. Gutierrez Resendez is conflicting out of these. Vice Chair, can I please get a motion?
Thank you, Madam Chair. I move that executive session items number 2, 3, and 4, the cases against Jennifer Massey, be dismissed.
Thank you. Commissioners, you've now heard the motion on agenda items 2 through 4. Administrator, may I please call the roll?
Commissioner Jancy,
Aye.
Commissioner Burke,
Aye.
Commissioner Mettler,
Aye.
Commissioner Thompson,
Aye.
Commissioner Helt,
Aye.
Commissioner Resendez Gutierrez is abstaining. Chair Payne.
Aye.
Motion passed 6-0 with 1 abstention.
Okay, moving on to reports of preliminary review. Agenda item 5, Jenna Wallace.
He is here
In person. Good morning, Ms. Wallace. Thank you for joining us today. I just want to give you sort of the layout of how this is going to occur. First, the investigator is going to give a report of the preliminary review. And then we will allow commissioners to ask any questions of the investigator. And then we will allow you to give a short statement limited to 3 minutes. And then commissioners will be, we will open the floor to commissioners to ask you any questions, should they have any. And then commissioners will discuss the matter. And then the vote today before the commissioners is to decide whether to move this to investigation. There is going to be no decision today whether any violations actually occurred. So I just want to make that important distinction. And then, so that's the only decision that is before the commission today. Okay.
Thank you.
With that being said, let's see, Investigator Fenstermaker, can you please proceed with the report?
Thank you, Chair Payne. Commissioners, I'm Casey Fenstermaker for the record. The first matter for your consideration today is regarding Lincoln County District Attorney Jenna Wallace, case number 26-108 ECF. Jenna Wallace was elected to the district attorney position in 2024, but was appointed to that position early. At the time she was appointed in June of 2024, her husband was employed by the DA's office as a detective. Additionally, at the time she was appointed, the DA's office was considering a restructuring to prevent the loss of a detective position. Without the restructuring and based on the county's HR office, Jenna Wallace's husband would be demoted to a different, lower-paying position. When Jenna Wallace took office, she issued a statement on the Lincoln County District Attorney's website that with respect to her office's budget, she had a conflict of interest because her office's budget paid her husband's salary. She also issued a statement indicating who would act as her husband's direct supervisor and manager. After developing the materials and making those announcements, Jenna Wallace reached out to the Ethics Commission for both verbal and written advice regarding how to move forward with respect to her position as it related to her husband. When Jenna Wallace took over as DA, she began discussions with the county's HR office regarding the restructuring of the DA's office. Even though the restructuring could financially impact her husband, it does not appear she declared a conflict of interest related to those discussions. Additionally, Jenna Wallace may have used her position to financially benefit her husband by taking actions to attempt to move the restructuring forward. Ultimately, because the restructuring did not move forward, her husband was in fact demoted to a lower paying position. Jenna Wallace issued another conflict of interest statement in February of 2025, which addressed her husband's salary as part of her office's budget. Her conflict of interest statement also addressed the recall process and recalling her husband to the then vacant detective position. However, the conflict of interest statement only addresses the recall generally and not individual steps in the recall process or the budget process. The conflict of interest also does not address or negate what appears to be a prohibited use of office, as Jenna Wallace, as a public official, took actions that could financially impact her husband during the recall process. For if he were recalled, he would have obtained a higher paying position. Jenna Wallace also appears to have assigned her husband work, and while assigning work to him in and of itself may not have been a violation of the statute, it may have resulted in a prohibited use of office or conflict of interest if such assignments resulted in overtime or other financial impacts to him. Finally, during the hiring process for an open detective position for which her husband applied, it appears Jenna Wallace was involved in the process, attempting to resolve what was characterized as confusion regarding his background investigation. Based on information reviewed in the preliminary review, she did not declare a conflict of interest related to his hiring to that process. Further, her involvement may constitute a prohibited use of office. The interactions with her husband's recall and hiring process for the detective position also appear to violate the nepotism statutes in ethics law, specifically those statutes that require a conflict of interest disclosure. It also appears that she supervised her husband periodically during the time period in question in violation of the nepotism statutes. Thus, we believe there's a substantial objective basis to believe that a violation of ethics laws may have occurred, and the recommendation is to move this case to investigation.
Thank you, Investigator Fenstermaker. Commissioners, any questions for the investigator? Okay, seeing none. Ms. Wallace, now is the time for you to make a statement. We just ask that you keep it to 3 minutes or less.
I want to start by saying that I never expected to be an elected official. I ran in the 2024 primary when there was a vacancy. Essentially, the prior DA had withdrawn days prior to the filing deadline. I stepped forward, I ran. I ended up winning that primary and ultimately was appointed a month later. I was 34 years old. I had been the chief DDA for 6 months. I had 2 toddlers at home. And I inherited an office that had 8 prosecutor vacancies, as well as employed my husband. The first week of being DA, I learned honestly what OGEC was. I learned what a conflict of interest was. I created a nepotism policy. And over the course of my husband's employment, I repeatedly tried to delegate my authority pursuant to OGEC's guidelines to other people, including a DOJ prosecutor that was embedded in my office, one of the local county commissioners, as well as other management in my office. The county either told me I could not delegate my authority to those individuals or ultimately terminated someone for acting underneath that delegation. And ultimately, my husband ultimately was terminated by the county about a year ago. The former sheriff and the current sheriff both have conflict of interest. And while they were in office, they delegated their authority. The county has never once questioned their delegation of authority. It has only been mine. I understand that my intent here is really irrelevant, but I do want to stress that I really tried to do the right thing. I reached out to OGEC on several different occasions. I issued an amended conflict of interest statement when I felt my conflict had changed. Myself and my husband have never received any financial benefit from any of the allegations. And many of the situations involved employment rights my husband had under the contract that he would have had regardless of me being in the position or not. I will also note that the timing of the complaint was slightly odd, only because my husband has not been employed in my office for about a year. He's employed elsewhere now. I really wish this had been filed while he was in my office so that I could have been educated about what I was doing wrong. I could have implemented changes and avoided any issues. However, I will say that it feels a little bit like small town politics are using OGEC in like kind of this weaponized way for their own agenda. I've had a very tumultuous relationship with the county. It predates me being the DA. And oftentimes our conflict plays out in the media, including this complaint, which was released to a private citizen back in April. It was published online. The private citizen issued press releases regarding this complaint and then ultimately verbatim submitted it to the Oregon State Bar for another ethics complaint. I will say it's been a crash course in being an elected DA. I've learned so much in the last 2 years. I have so much more to learn. I recognize that. My husband is not employed in my office. I will never employ a relative in my office again. And I really appreciate OGC being available for phone calls over the years in some really complex situations. I'm here to answer any questions that you might have. And I just really appreciate the opportunity to speak with you guys today.
Thank you so much. Commissioners, any questions for a respondent? Ms. Wallace, thank you so much for your candor. Do you deny any of the allegations in the report?
I do. I mean, it's hard because I think there's some pieces where more information would be really beneficial to, I guess, clearing my name. If I don't know if that's the right proper way, but for example, my husband never got a detective badge after he was demoted. The emails where I asked, I noted it was at like 9 p.m. or 8 p.m. at night, asking if someone was deceased or if he could review a report. That was because I was working those late hours, not him working those late hours, right? Those are things that he just did during the normal course of the following day. And so I didn't view that as assigning work. I thought that was just me asking him to do what his job was as a detective. But I can see now on the other side of things how maybe that was too close to the line. So I don't believe I've done anything wrong, but I also have learned a lot through this process as well.
I mean, I think this is another situation where additional information may be helpful, and maybe ultimately your name could be cleared, but I think I would benefit from additional information. And so I'm leaning towards moving this towards investigation. I hear you. I think small town politics are difficult in these situations. Sometimes complaints are not filed for the proper reasons, but it seems to me like I have questions that I would like to have answered in this situation. That's just for me. I also really appreciate, I want to tell you that I really appreciate your efforts at doing the right thing. So, most likely, I think this would ultimately lead to a letter of education because of your efforts and trying to do the right thing, contacting OGEC and all those things. But you know, our rules don't allow us not to move things forward to investigation simply because of, intent is not a mitigating factor until we get to the end when we're looking at violations. But that's where I'm leaning. My colleagues may feel completely different than me, but I think sometimes in these situations, moving things to investigation can be helpful. And I just have some questions I'd like to be answered. Commissioners, anyone else want to discuss this further before we move to a motion? Commissioner Mettler.
Yeah, I just wanted to add, I agree with you that this is probably a good situation where we could, more information would be helpful, and then we feel like we have everything on the table to make the right decision. So yeah, I think this is a good opportunity for that, to move forward with investigation.
Thank you, Commissioner. Vice Chair, are you prepared to make a motion?
Make a comment first,
Oh,
if I could.
please.
Thank you, Madam Chair. I will reluctantly vote to move this forward, but I have two big concerns. First of all, I think Ms. Wallace did what she was supposed to do and what we should encourage elected officials to do in reaching out to the commission to ask for help. So I think that is a huge mark in her favor. And second of all, I am beyond disappointed at the people bringing this forward that they would file a complaint and then issue a press release about it. There is absolutely nothing in this process that gets me more mad than, this is an obvious use of the commission as a political weapon. And I'm not saying that we shouldn't investigate it, but it makes my blood boil that somebody would file a complaint and then a press release. That's absolute garbage in my opinion. So I'll make a motion to move it forward, but I make it reluctantly.
Thank you for those comments, Vice Chair. So have you made your motion?
I have not.
Okay.
All right. Madam Chair, I move the commission find there's a substantial objective basis for believing that Jenna Wallace may have violated ORS 244-040 sub 1, ORS 244-120 sub 2, ORS 244-179 sub 1, and ORS 244-177 sub 1, and that the commission should investigate accordingly.
Thank you, Vice Chair. Commissioners, you've heard the motion. Administrator, please call the roll.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Helt,
Aye.
Commissioner Burke, Commissioner Burke,
I'm sorry, I was muted. Aye.
thank you. Chair Payne,
Aye.
motion passed 7-0.
Okay, Ms. Wallace, thank you so much for appearing today. And again, thank you for your candor. All we've done today is move this to investigation. Staff will be in touch with you about next steps. Again, there's been no finding of any violation. And we'll, again, staff will be in touch with you. Hey, thank you for appearing today.
Thank you so much.
Six has not responded to any of our messages trying to get. Yeah, it's okay.
It's okay.
Yeah, use it.
Okay. Okay, so not yet here. So we'll just move forward.
I think you can do the case.
Okay.
He's been notified.
Okay. Okay, we're moving to executive session agenda item 6, Jim Parks, who is not yet appearing. So we'll just move forward. Investigator Sullivan, Can we have the report,
Can
please?
we have a moment to let the, or are we moving forward 6? Sorry, I apologize. Sorry,
We're good.
I apologize. You're good.
That's fine. You can interrupt me anytime. Okay, Investigator Sullivan, please proceed.
Okay. Yes, thank you, Chair Payne and Commission. This is Investigator Josh Sullivan for the record. I'm presenting executive session agenda item number 6. This is a complaint against Jim Parks, chairman on the board of directors for the Blue River Water District. The complaint in this case alleges that Jim Parks used his position with the Blue River Water District for personal gain on multiple occasions. It states that Jim Parks appointed himself to a paid superintendent position at a board meeting on December 11th, 2024. The recording of the December 11th board meeting indicates that Jim Parks made a motion and voted to terminate the previous superintendent, and then he introduced a proposal to act as the interim superintendent himself. After he voted to appoint himself as the interim superintendent, he asked if he could vote. Another board member replied and said that he should abstain. However, the board did not redo the vote. By nominating himself to become the interim superintendent and voting to appoint himself to the position, it appears that Jim Parks may have violated the prohibited use of office and conflict of interest provisions of government ethics law. The complaint also alleges that Jim Parks took action to increase his own superintendent's salary. However, there is no information to indicate that the salary increased or that Jim Parks advocated for a salary increase. The complaint also alleges that Jim Parks connected his private irrigation system to a district fire hydrant located in his front yard and used district supplied water to irrigate his personal property for approximately 2 weeks. Jim Parks stated that in August 2023, when the Lookout Fire was approaching his property, he had permission to use his personal tools to connect a hose to the fire hydrant and extinguish burning maple leaves that were floating onto his property. It does not appear that Jim Parks used his official position or took actions in his official capacity to provide himself with the benefit of district supplied water, and it appears that his actions were taken in his personal capacity as a homeowner. Based on the information available in this preliminary review, there appears to be a substantial objective basis to believe that Jim Parks may have violated the conflict of interest and prohibited the use of office provisions of Oregon government ethics law, and the recommendation is to move this case to investigation.
Thank you, Investigator. Commissioners, any questions for the investigator?
Actually, Chair, I have one question.
Yes, Commissioner Jancy, please proceed.
And I'm in favor of moving this forward to investigate. I'm just trying to make sure I understand our thinking on the statute. Is it important whether his vote was necessary to actually pass the motion to remove the prior official, or would his initiating that motion alone be sufficient? Do you have a sense of that, or?
I think the important part is whether he declared the nature of his actual conflict prior to taking action, and there were 2 actions that he took, nominating himself and then voting on it. So, I mean, I do agree that the action he took afterward to kind of resolve that a little bit did kind of mitigate it, but he did have a conflict that he declared, it appears.
Yeah, I'm sorry. I might have been misunderstanding, but I guess I was speaking more towards, was he the person that initiated the motion to terminate the prior official that he stepped into the position for?
Yes, I believe so.
Okay.
Sure.
All right. Okay. All right. Thanks.
Thank you, Commissioner Jancy. Commissioner Held.
Thank you, Chair. I think it said in the report that he was not necessary to pass the motion. Am I correct in that?
Yes, thank you for the question, Commissioner Hell. There were enough other commissioners that it could have passed if they did revote.
Okay, thanks for the clarification. Thank you.
Thank you, Commissioner Halt. Any other commissioners have questions for the investigator? Okay, opening it up for discussion, thoughts. Vice Chair, are you ready to make a motion?
Ma'am, I move the commission find there's substantial objective basis for believing that Jim Parks may have violated ORS 244040 sub 1 and ORS 244120 sub 1, and that the commission should investigate accordingly.
Thank you, Vice Chair. Commissioners, you've heard the motion on executive session agenda item 6. Administrator, please call the roll.
Commissioner Halt,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mettler,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Chair Payne.
Aye.
Motion passed 7-0.
We have Mr. Elkinich.
Yeah, second. 7 and 8.
Is Ms. Bennett appearing as well, or just her lawyer?
Both should be appearing.
They both, okay. And it is Dr. Adrian Benny. Thank you so much.
They are on and should be good to go.
Hi, Mr. Elkinich. How are you?
Hi, good morning, everybody. I'm well, thank you. I hope you all are doing well as well too.
Is your client Dr. Bennings with us today?
She should be. The last I heard, she was in, I thought she was also in the waiting room. But I don't
Oh,
know.
I think I see her. Her camera is just not on.
She-
Dr. Bennings, can you hear me?
Oh, I do see that she's on, yes.
She's been given permissions. Dr. Bennings, can you hear me? This is Chair Payne. My name's Cheryl Payne. I'm the chair of the commission. Can you hear me?
Excuse me, Chair, she's calling me right now. She might have an issue. May I go off mic real quick to answer?
Yes, please.
Hi, Chair Payne. There may be I'm sorry, I can hear myself twice through my phone and through the audio. I apologize. She said that the sound worked fine in the waiting room. She tested her mic and everything. But then once she got put into the meeting, she can see everybody, but then now it's grayed out at the top and she doesn't know if she doesn't have permission or if permissions were not granted to her when she joined the meeting.
It was, but I'll reset it real quick. See if that
Okay,
works.
we're gonna try to reset that and see if we can fix that. Thank you for letting us know.
Wonderful, thank you.
That's been reset.
Okay, it's been reset. Can Dr. Benning, can you try to try again? maybe have her.
Chair, we can text her the phone number to call in and she can call in
Okay.
so that I'll
She,
have her.
so she's just gonna try to rejoin one time and
gonna
see
say.
if that fixes the connection. And then if that doesn't, then maybe we could try the phone number.
Okay.
Thank you all for your patience. We both appreciate it very much.
Technology happens. If this doesn't work, we'll give her a phone number to call in so we can
What?
just move forward. Yeah.
I believe. I believe that should be there. It also might, well, let's let her try first.
There she is.
Okay,
Dr.
I logged
Bennings.
in with my husband's account. Sorry.
No problem. Welcome.
Okay.
My name's Shanoa Payne. I'm the chair of the Oregon Government Ethics Commission. So I just kind of want to give you a short layout of how this is going to go. We're going to hear both your matters. We're going to hear them individually. And we will proceed with item 7 and then with item 8. First, the investigator will give a report, and we will allow the commissioners to ask any questions of the investigator. And then we will allow your attorney or yourself or both of you, should you wish to give a short statement. We will just ask that your statements be limited to 3 minutes or less because we have a long agenda today. And then we'll open the floor for commissioners to ask any questions, should they have any, of either you or your lawyer. And then we will proceed to our decision or our vote, keeping in mind that on number 8, the recommendation is to move to dismiss that matter. But on number 7, the recommendation is to move to investigate. On number 7, I just want to emphasize that no decision or, the only decision before us is whether or not to move that to investigation. There is no decision or vote today as to whether any violation has occurred. I just want to make that very clear. With that said, I'm going to turn this over to our investigator, Josh Sullivan, to provide the report.
Yes, thank you, Chair Payne and Commission. This is Investigator Josh Sullivan for the record. I'm presenting executive session agenda item 7. This is a complaint against Dr. Adrian Bennings, former president of Portland Community College, or PCC. The complaint in this case, there are multiple complaints that allege that under Dr. Adrian Bennings' leadership, PCC adopted the phrase "one together, together one" as its institutional slogan. They state that in August of 2023, Adrian Bennings' business, G7 Enterprises LLC, filed a federal trademark application for the phrase "one together, together one." The complaints in this case allege that Dr. Adrian Bennings used and promoted the phrase "one together, together one" as the president of PCC, while simultaneously trademarking the phrase and using it on her personal website and in connection with her private business. The information in this preliminary review indicates that Adrian Bennings used the phrase "one together, together one" when she was a finalist in the selection process to become the PCC president. And after being selected, she continued to use the phrase both in her personal capacity and her professional capacity. She used the phrase when describing her mission as PCC president during the 2022 in-service address, and it appeared on the PCC website, her email signature, and other messaging from the Office of the President. According to a newspaper article, she had track relay batons made to emphasize her "one together, together one" slogan. In 2023, G7 Enterprises LLC filed a trademark application for "one together, together one." The application indicates that the phrase was first used in commerce as early as March 23, 2022, and it indicates that the phrase was used in a point of purchase display on the website www.adrianbennings.com. The trademark application states that it was used for professional coaching services in the field of personal branding, leadership, wellness, and personal development. It appears that Dr. Adrian Bennings continued use of the phrase one together, together one after trademarking the phrase, both for her personal business and for PCC. Further, it appears that she directed that the phrase be used on PCC properties such as relay batons, while also using the phrase on her personal website, which advertised services such as leadership coaching, motivational speaking, and strategic planning. Based on the information available in this preliminary review, there appears to be a substantial objective basis to believe that Dr. Adrian Bennings may have used her official position to create an opportunity for her own financial gain. But for her position as PCC president, she would not have had the opportunity to promote the phrase on PCC messaging, both before and after it was trademarked. Thus, it appears that Dr. Adrian Bennings may have violated ORS 244.040 sub 1 and ORS 244.120 sub 1 sub C, and the recommendation is to move this case to investigation.
Thank you, Investigator Sullivan. Commissioners, any questions for the investigator? Seeing and hearing none. Now will be the time to have statements from Mr. Elkinich or Dr. Bennings. I'll let you two decide what order or who's speaking.
Thank you very much. And good morning, Chair Payne and commissioners. Thank you for the opportunity to be heard today. As you know, my name is David Elkinich. I'm an attorney with Buchalter LLP, and I represent Dr. Bennings. I'm just going to make a few brief legal points, and then Dr. Bennings would like to address the commission personally. I know that you're handling both matters separately today. I'm going to just address them briefly together because with respect to item 8, which is involving the allegation of PCC portraits, I understand that staff is recommending a dismissal on that matter, and we just simply respectfully ask the commission to adopt that recommendation. And I won't provide further comment on that when the commission considers that under item 8. Turning to this matter, which is item 7, the issue is not whether a phrase associated with Dr. Bennings was also used in PCC communications or whether a care-related image appeared in an illustrative example on a website. The issue is whether the record establishes a substantial objective basis to believe that Dr. Bennings used her office to obtain a private financial benefit or that she failed to disclose a legally cognizable conflict of interest, and here it does not. On use of office, the preliminary review identifies no payment from PCC to Dr. Bennings, no contract, no license, no royalty agreement, and no business transaction between PCC and G7 concerning the phrase one together, together one. The report also notes that PCC did not pay G7 to use the phrase and had no agreement with G7 or Stuck Up Studios. And while the report characterizes Dr. Bennings' personal website as commercial and says it appears the phrase was used to advertise private consulting services, it does not identify any actual consulting engagement, client contract, sale of service, or revenue tied at all to the phrase. So even if there was some parallel use of the phrase, the record does not show the kind of private financial benefit required by the statute. Second, with respect to the care image, it appeared only as an illustrative example among other sample magnets. There were no sales or attempted sales of PCC branded merchandise. The review identifies nothing on that issue. Third, on the conflict of interest, the report does not identify a PCC decision, recommendation, contract, license, or other governmental matter involving a financial relationship between PCC and Dr. Bennings or her business. Without a matter of that kind and without an identified private financial effect, there is no substantial objective basis to conclude there was an obligation to disclose under 244.120 sub 1. All in all, the record may show a parallel use of the phrase and the use of an illustrative image, but it does not show the elements required to move this case into investigation. And as a result, we would ask you to dismiss this one as well as item number 8. Since we will not have a comment on the next item, I would ask that you offer Dr. Bennings an opportunity to address the commission briefly.
Thank you, Mr. O'Connich. Dr. Bennings, now is the time for you to make a statement. And again, we're going to just limit your time to 3 minutes. Thank you so much.
Thank you. Well, first of all, good morning. And I want to start with, I recognize and respect OGEC's role, including the right of individuals to file complaints in good faith and pursue accountability through the proper process. At the same time, it's important that I also want to acknowledge the very real lived experience of this process as a Black woman leader in the state of Oregon. These complaints did not arise in a vacuum. They unfolded during an exceptionally difficult period for the college, marked by a historic strike, program cuts, and sustained fiscal pressure, and they have been used as a tool to discredit my character, damage my reputation, diminish my credibility, and lead the public to question my integrity. That said, I respectfully ask the commission to focus on the legal standard and on the record. I disagree with the suggestion that access alone, or the idea that but for my position, I had the opportunity to use certain phrases or themes or materials establishing an ethics violation. Presidential communications exist because of the office, and that fact alone does not establish private financial gain, avoided financial detriment, or a conflict of interest. The phrase "one together, together one" was first used in March 22 during the presidential search at PCC as part of my leadership message as a candidate. The preliminary review itself reflects the phrase appeared in materials associated with my candidacy, and that the trademark application identified first use as March 23, 2022. I later trademarked the phrase as a protective step, not as a commercial arrangement with PCC. The record does not show any contract, payment, license, royalty, or other financial arrangement between PCC and me, or any associated business regarding the phrase. A preliminary review states that PCC did not pay G7 LLC to use the phrase, did not have any agreement with G7 or stuck up. And since the trademark application was submitted in 2023, I have not offered, contracted for, or provided professional services using that phrase. The same is true of the care-related allegation. The preliminary review summarizes that the image referenced on the Stuck Up Studio website was used only as an illustrative example, was not a product offered for sale, and I did not sell or attempt to sell PCC branded merchandise. So for these reasons, I don't believe that the use of a leadership phrase in presidential communications or the allegations regarding care-related materials constituted a prohibited use of office or conflict of interest under the Oregon ethics law. The relevant question is whether I use my position to obtain a private financial benefit or avoid a private financial detriment. I did not. I respectfully maintain the record does not establish a substantial objective basis for concluding that any financial benefit, avoided financial detriment, or private pecuniary benefit occurred, and respectfully ask the commission to not move this matter forward. Thank you.
Thank you, Dr. Bennings. I'm going to open it up to commissioners for questions of our respondent or of Mr. O'Connich. Commissioner Halt.
Thank you, Chair. So I have a question of why the phrase was trademarked after it was already used.
Commissioner Halt, are you directing your question to a specific person?
Either the lawyer or Dr. Bennings.
I think that Dr. Bennings would likely be happy to answer that question for you. I believe that they trademarked that phrase. It was a phrase that she had developed prior to taking the position at PCC, and a phrase that she may want to use after PCC, but not something that she was using for a private financial gain while she was employed at PCC. And if that's not correct, Dr. Bennings, you can correct me.
That's correct.
Dr. Bennings, I have a question for you. Is your website advertising coaching services still up and running?
So my website never advertised coaching services or sales or anything. It was an extension of my LinkedIn. And it is not up and running.
Thank you.
Chair, I have a question
Commissioner Jancy, please.
for Mr. Elkanich, I think. How would you respond to a concern that the trademark and the use establishes an opportunity in the future for Dr. Benning to potentially obtain financial benefit from trying to enforce her trademark rights against PCC? Not suggesting that she intends to do that, but how do you see that that possibility as relevant or irrelevant to our inquiry?
Thank you, Commissioner. It's a good question. I think that we can answer that, I think, pretty directly. As you know, Dr. Mennings is no longer, she's no longer president of the university. And I believe that in her separation agreement, she has released any claims relating to the use of the phrase. So there could be no allegation that she could bring a claim against PCC later.
Okay, thank you.
Dr. Bettings is nodding, so I assume I said that correctly, which is good.
You did.
I have a question for Mr. Elkanich. How would you respond to the fact that the use of office statute prohibits attempting to use official position or office to obtain a financial benefit? It seems like your response is stating that there's no violation simply because there was no actual financial benefit, but it seems that the statute prohibits attempting to use the official position to obtain a financial benefit. It doesn't seem like your response is addressing that language in the statute.
Yeah, Chair Payne, thank you for that question. Certainly, I think the latter part is a very easy part to answer in that there was no financial gain. I think that here you have to be able to demonstrate there was an attempt, and there's also just simply no attempt at a financial gain. There's no evidence that she attempted to use this phrase to actually do consulting services, or that she actually used the phrase to obtain a financial benefit while president of PCC. And so in some ways, they kind of go hand in hand. She didn't receive a benefit, but she also didn't attempt to obtain one either.
Commissioner Halt, please.
Thank you. Thank you, Chair. So you mentioned that that Dr. Bindings is no longer president of the university, and there's a separation agreement. My concern is that when she trademarked it, she made an asset out of it, and an asset could be used for financial gain. And so what are the actual terms with the college so that there was no financial gain? I want to understand how that, and is there any use of the phrase afterwards where there is income being generated from the phrase that was created there? Thank you.
I'm happy to
Yes.
read the actual statement just so you all it can be aware of what it actually says, and I'll read that here really quickly. It's in section 2A, titled Release and Waivers of Claims, and I believe Attorney Elkanich also sent this to the investigator, but I'll read it here for clarity. And it says, further, as Dr. Bennings has clearly indicated is her intent, Dr. Bennings releases PCC from any and all claims she may have related to PCC's use of the one together, together one slogan.
Yes, Vice Chair.
So I may be oversimplifying this and somebody can correct me if I'm wrong, but my understanding is that Dr. Bennings created this When she went to PCC, they used it. She's now released PCC. If they continue using it, she can make no claims. I see that differently, as if she had worked with PCC's marketing team to create this. They created it with PCC money, and then she takes it with her. That's a completely different thing to me than she created this herself and brought it with her and now has released claims. So I guess I just don't see where she would receive any kind of benefit. I think the reverse is true. I think PCC, should they continue to use it, which it sounds like they can, would receive the benefit, not her. So I guess I'm struggling to see where the issue is here.
Well, a potential counterpoint is that the act of trademarking and then the existence of the release of claims, I mean, frankly, it demonstrates that there was a possibility that she could enforce her rights as against the university while she was there prior to that release. So, yeah, it's a difficult situation. I'm not suggesting there was an intent, but it's at least in my tenure, it's a sort of an unusual situation that we're faced with.
Commissioner Halt.
Thank you, Chair. I agree with both Commissioner Jancy and Commissioner Thompson. I think that my interests have been satisfied that the university can keep the slogan, and there's no cost that's exchanging. But I did have a lot of trepidation about the asset being created. But I think what I'm hearing is it's just a protection so that she could use a phrase that she brought there before, after she left. And there's really no money exchange. So I do believe that it's, the university that's getting the benefit. And so I would lean towards dismissal.
Thank you, Commissioner Halt. I still have a lot of questions, so I would like to move this to investigation because I just don't feel satisfied at this point that I feel comfortable dismissing, but I understand if other people feel differently. So I just would like more information at this point. That's where I'm left feeling. So, but if you want to make a different motion, Vice Chair, it sounds like we may have a split here, so we could make a different motion and see how that goes. And
Sure.
Okay.
See where it goes. Madam Chair, for executive session item number 7, I move the commission dismiss the complaint against Adrian Bennings.
Okay, commissioners, you've heard the motion. The motion is to dismiss. Administrator, please call the roll.
Commissioner Halt,
Aye.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Nay.
Commissioner Burke,
Nay.
Commissioner Resendez Gutierrez,
Nay.
Commissioner Thompson,
Aye.
Chair Payne.
Nay.
Motion failed 3-4.
Let's try it the other way.
Do you want me to make the motion?
I'm happy to do it.
Okay.
I move the commission find there is a substantial objective basis for believing that Adrian Bennings may have violated ORS 244-040 sub 1 and ORS 244-120 sub 1, and the commission should investigate accordingly.
Okay, commissioners, you've heard the alternative motion. Administrator, please call the roll.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson.
Aye.
Sorry, did you say aye?
Yes, aye.
Thank you. Commissioner Jancy,
Aye.
Commissioner Mettler,
Nay.
Commissioner Helt,
Nay.
Chair Payne.
Aye.
Motion passed 5-2.
Okay, Dr. Beddings, this,
Madam Chair, can I make a vote explanation real fast since I changed mine?
yes,
I just didn't want this to be administratively dismissed. I wanted resolution one way or the other, so I did change my vote in order to get that resolution one way or the other.
thank you, Vice Chair, for your explanation. So Dr. Bennings, the commission did vote to move this to investigation. As you heard, it was a difficult vote for the commission, but no decision was made that any violation has occurred. We just wanted more information, and it may ultimately be dismissed. We're not sure, but we're just going to gather more information and proceed to invest a full investigation in this matter so that we can make a decision on a full record. Okay. Thank you so much. We're going to proceed to item number 8, understanding that the recommendation in this matter is to move to dismiss, but we will hear a report from the investigator. Investigator Sullivan.
Yes, thank you, Chair Payne and Commission. This is Investigator Josh Sullivan for the record. I'm presenting executive session agenda item number 8. This is a complaint against Dr. Adrian Bennings, former president of PCC. The complaint in this case alleges that Dr. Bennings used publicly funded professional PCC photography for private commercial purposes. The information in this preliminary review indicates that PCC commissioned a professional photographer and utilized PCC staff to take photographs of Adrian Bennings for press purpose communications and other official purposes. Some of the photographs were posted to the PCC website for public use. In preliminary review, the Director of Public Relations for PCC stated that PCC allows unlicensed use of the photography, and the photographs should all be used for promotion within the context of the college and representing PCC. The information available in this preliminary review does not appear to indicate that Dr. Bennings took action in her official capacity to use PCC funds or to obtain photography for her business. Nor does it appear that she was only able to use the photography owned by PCC because she was the PCC president. Thus, it does not appear that the PCC photography was only available to her because of her official position. In this case, the information appears to be insufficient to constitute a substantial objective basis to believe that Dr. Bennings violated the prohibited use of office or conflict of interest provisions of Oregon government ethics law, and the recommendation is to dismiss the case.
Thank you, Investigator Sullivan. Commissioners, any questions for the investigator on agenda item number 8? Seeing and hearing none, we will proceed to a motion.
Thank you, Madam Chair. For executive session agenda item number 8, I move the commission dismiss the complaint against Adrian Bennings.
Thank you, Vice Chair. Commissioners, you've heard the motion on agenda item 8. Administrator, please call the roll.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mettler,
Aye.
Commissioner Helt,
Aye.
Chair Payne.
Aye.
Motion passed 7-0.
Dr. Bennings, this matter has been dismissed. We thank you for appearing today. We thank you for your candor. We thank you for your professionalism. And staff will be in touch about next steps on agenda item number 7.
Thank you.
Thank you all very much. Bye now.
Thank you.
No,
No, it makes sense.
I can see both sides of it.
Okay, so
his.
no one's appearing on 9. Right?
Again, I'm sorry.
No one's appearing on 9. Okay. All right, we are moving forward on executive session, agenda item 9, and Investigator Pacheco, please provide the report.
Thank you, Chair Payne and Commissioners. This is Investigator Daniel Pacheco for the record. Agenda item 9 in your meeting books is a preliminary review report for Carol Raymond, Mayor for the City of Antelope. In this case, Mayor Raymond and her spouse, Patrick Raymond, were elected to the City Council in February 2026. The complaint in this matter concerns an April 9, 2026 City Council meeting during which the Council discussed and voted to approve a water operator stipend for Mr. Raymond. Based on the information gathered, it appears that Mayor Raymond violated multiple provisions in ORS Chapter 244. In this case, it appears that at the April 9th meeting, Mayor Raymond failed to declare the nature of her actual conflict of interest prior to the City Council's consideration, and again during the vote to approve her spouse's water operator stipend. By failing to do so, it appears that Mayor Raymond violated ORS 244.120 sub 2 on 2 separate occasions. It also appears that Mayor Raymond may have taken actions that would constitute a prohibited use of position. In this case, it appears that Mayor Raymond used her position when adding the water operator stipend for her spouse to the April 9th meeting agenda and during the meeting when attempting to persuade the council to approve the stipend. These opportunities were only available to Mayor Raymond, but for her official position. Thus, it appears that she violated ORS 244.040 sub 1 on 2 separate occasions. The complaint further asserted that Mayor Raymond may have violated the nepotism statutes and ethics law, when she participated in the decision involving the stipend for her husband. In this case, when Mayor Raymond's spouse initially took over the water operator responsibilities in January 2026, it appears that he was volunteering. However, at the April 9th meeting, the position was converted to a paid position. Therefore, if Mayor Raymond directly supervises the position of water operator and there was no policy regarding the direct supervision, it is possible that she may have violated the nepotism statutes by proposing and voting to approve the stipend for her spouse. Should this case move to investigation, Commission staff will seek to determine whether Mayor Raymond supervises a water operator, how Mr. Raymond was appointed to the position, whether the position is a volunteer one, and if applicable, whether there is a policy in place regarding Mayor Raymond's direct supervision of the now paid water operator position. Based on information available in this preliminary review, there appears to be a substantial objective basis to believe that Mayor Raymond violated ORS 244.040 sub 1, ORS 244.120 sub 2, ORS 244.177, and ORS 244.179, and the Commission should investigate accordingly. Thank you.
Thank you, Investigator Pacheco. Commissioners, any questions for the investigator? Vice Chair.
Did I hear you right that the mayor and her husband were both elected to council? The mayor didn't declare a conflict, but her husband did, because I assume we don't have a complaint for him. So can you tell me a little bit about how that happened?
So there was apparently a lot of council members back in October, November, a lot of the city council members resigned, and there was a special election, and both Mayor Raymond and her husband applied for the positions, and they were elected during the election, and they both were appointed to their position on the city council in January 2026. During that period, Mr. Raymond had begun working to get licensed to become the city's water operator. And so when they were elected, he then started doing the water operator duties on his volunteer pro bono capacity. And then at the April 9th meeting, that's when the discussion was brought forward to pretty much essentially turn it into a paid position for him.
Right, but how did he vote on that April 9th?
Oh, sorry.
That's what I was trying to get at.
Sorry, the April 9th, my understanding is he did not vote. He was told not to vote. He was told
Okay,
not to vote.
that makes sense. Thank you.
But did he declare conflicts or did he just not vote?
Based on the meeting materials, which were very limited, it doesn't appear that he did, but the complaint wasn't concerning him, so I didn't look further.
Just weird to me, but
Yeah, okay.
He could have left the room. But okay, I'm just curious. Thank you. I'm good.
Commissioner Held?
Thank you, Chair Payne. I am going to vote to move this forward. However, I just wanted to express some concern around these rural communities. It states there's 37 people in town. I mean, the conflict of interest and the nepotism is at a different level. I really would like to see us develop something for these small towns to where it's more scripted towards them and gives them a little bit more rules where literally everybody in town knows everybody. I don't know how you could possibly run meetings correctly But I do think this case, I am going to vote to move forward, but I would love to see if we as a commission could develop something that makes a little more sense for towns of 37 for their ability to conduct meetings. Thank you.
Thank you, Commissioner Halt. Good comments. We do have small rural communities. Public officials come before us quite often in these sorts of situations. So I agree it would be helpful to sort of consider those difficult situations. Any other comments from commissioners? Okay, seeing and hearing none, Vice Chair, can we get a motion?
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Carol Raymond may have violated ORS 244-040 sub 1, ORS 244-120 sub 2, ORS 244-177, and ORS 244-179, and that the commission should investigate accordingly.
Thank you, Vice Chair. Commissioners, you've heard the motion on executive session agenda number 9. Administrator, please call the roll.
Commissioner Burke,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Thompson,
Aye.
Commissioner Helt,
Aye.
Chair Payne.
Aye.
Motion passed 7-0.
Okay, moving on to executive session agenda item 10. Investigator Pacheco, please provide the report.
Thank you, Chair Payne and Commissioners. This is Investigator Daniel Pacheco for the record. Agenda item 10 in your meeting books is a preliminary review report for Stephanie McKinnon Border, Child Protective Services Worker for the Oregon Department of Human Services Child Welfare Division. In addition to her public role, Ms. McKinnon Border is the owner of God and Horses, a business that provides equine assisted therapy. The complaint in this matter alleges that Ms. McKinnon Border was met with conflicts of interest and used her official position to receive child welfare referrals that would financially benefit her business. However, based on multiple interviews and information provided by DHS child welfare staff, it does not appear that was the case. Therefore, the recommendation in your books is to dismiss. Thank you.
Thank you. Love the brevity. Commissioners, any questions for our investigator? Seeing and hearing none, Vice Chair, can I get a motion?
Thank you, Madam Chair. For executive session agenda item number 10, I move the commission dismiss the complaint against Stephanie McKinnon Border.
Okay, Commissioners, you've heard the motion on executive session agenda item 10. Administrator, please call the roll.
Commissioner Thompson,
Aye.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Burke,
Aye.
Commissioner Helt,
Aye.
Commissioner Resendez Gutierrez, Commissioner Resendez Gutierrez. All right, Chair Payne.
Aye.
Motion passed 6-0.
Okay, moving forward to, I think what we'll do is we'll try to get through these motions to dismiss, and then we'll take a short break. So moving on to executive session agenda item 11.
Thank you, Chair Payne and Commissioners. This is Investigator Daniel Pacheco for the record. Agenda item 11 in your meeting books is a preliminary review report for Benjamin Tatone, Commissioner for the City of Roseburg Homeless Commission. The complaint in this matter alleges that since joining the Homeless Commission, Mr. Tatone was met with conflicts of interest and used his official position in recommending that the city establish a houseless camp away from an area where his businesses own properties. However, based on the Homeless Commission meeting materials and the response provided from the city manager, the Homeless Commission has never discussed where to move the houseless camp, and in fact, several years prior to Mr. Tatone's appointment, the Homeless Commission had voted to have that decision be made by the City Council. Thus, the recommendation in your books to dismiss. Thank you.
Thank you, Investigator Pacheco. Any questions for the investigator? Seeing and hearing none, Vice Chair.
Thank you, Madam Chair. For executive session agenda item number 11, I move the commission dismiss the complaint against Benjamin Tatone.
Thank you, Vice Chair. Commissioners, you've heard the motion on executive session agenda item 11. Administrator, please call the roll.
Commissioner Jancy,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Burke,
Aye.
Commissioner Mettler,
Aye.
Commissioner Thompson,
Aye.
Commissioner Helt,
Aye.
Chair Payne.
Aye.
Motion passed 7-0.
Okay, we are moving on to executive session agenda item 12. Commissioner Burke is recusing himself from participating in this, but will appear as respondent. Executive Director Myers is giving the report on this one.
Thank you, Chair Payne, Commissioners. For the record, this is Susan Myers. So the complaint in this case was filed by a resident of Lincoln City who alleged that Commissioner Burke had a conflict of interest involving two separate public meetings law cases that were filed against Claire Hall, former Lincoln County Commissioner, and the other commissioners, because he either, in one case, was a member of one of the recall PACs that was seeking the recall of Ms. Hall, and in another case, knew people involved in a separate recall PAC. As the report in your meeting books outlines, the timeline of events. So there were 3 meetings of the commission at issue. On October 10th, the commission, at the October 10th meeting, the commission considered the preliminary review reports involving Commissioner Walter Chuck and Commissioner Casey Miller. The report for Commissioner Hall had been removed from the meeting agenda because she was in the hospital. So at the October 10th meeting, only decisions being made applied to the other 2 commissioners. There were no recall efforts for those commissioners. And the only recall PAC that existed at the time of that meeting was recall PAC number 1, which did not have, for which Commissioner Richard Burke had no role. In that meeting, he did announce that he knew a friend of his was involved in the recall efforts. That announcement was made in executive session, not beforehand. But all of this goes to the advice that I've given commissioners repeatedly about being very specific about when you are announcing a statutory conflict of interest versus some other reason for abstaining. So at the October 10th meeting, he did not have a statutory conflict of interest. He was not a member of the recall, and there was no financial benefit to him in the votes that were taken for either Mr. Chuck or Mr. Miller. The preliminary review report for Claire Hall was subsequently, as I said, pulled from the agenda and then subsequently heard at the commission's December 12th meeting. By the December 12th meeting, recall PAC number 3 had been formed, and Richard Burke was the treasurer of recall PAC 3. Now, recall PAC 3, even though he may have served as its treasurer, it is not a business and therefore could not be a business with which he's associated. Additionally, Richard Burke was not present at the December 12th meeting and therefore could not and did not participate in any deliberations or decisions made with respect to that preliminary review report. The complaint asserts that even though he was not present, he had some duty to disclose a conflict of interest otherwise, but you only have the duty to disclose if you are participating in making a decision or deliberating toward a decision or action on the matter giving rise to a conflict. So Then we get to the second complaint, via public meetings law complaint filed against the three commissioners. It was filed in November and was due to be heard at the commission's February 6th meeting. At that meeting, by the time of that meeting, Claire Hall had passed away. The recall pact that Richard Burke served on had been terminated. In addition, in the interim, on December 30th and 31st, there was campaign civil litigation that got filed in Lincoln County. It was originally filed by a member of another PAC, and then on December 30th, the following day, on December 31st, an amended complaint was filed, and Richard Burke was named as a plaintiff, and he submitted a declaration in support of the complaint. That separate campaign litigation also had terminated prior to the date of the commission's February 6th meeting. The campaign litigation was dismissed on January 14th. So at the February 6th meeting, Richard Burke, prior to the commission moving into executive session, announced a potential conflict of interest because he had served as the treasurer of the recall PAC, even though by February 6th, that recall PAC no longer existed. And he did not vote on the commission's actions with respect to the preliminary review for Claire Hall in the executive session. The commission did administratively dismiss the case. And then subsequently in the public session, the commission also administratively dismissed the investigation from the prior case. So he did not participate in the discussions or vote on those, albeit he could have participated in the discussions because he had announced a potential conflict. And in fact, when we actually look through the relationships, while there may be an appearance of impropriety and there may be very good and reasonable reasons to abstain and make a public announcement of the nature of your roles, making a decision on the preliminary review, it does not appear that it would give rise to a statutory conflict. There is no financial impact on Richard Burke, his relatives, or household members. The recall PAC, one, did not exist by the time of the decisions, but even had it, it is not a business with which you would be associated. During the course of the preliminary review, the complainant submitted a fairly lengthy supplemental memorandum in which she raised additional allegations. And so in looking at those allegations, they were that Richard Burke used his title and his history of service on this commission on the website, on his bio, on his Western Liberty Network's website. The commission has never held that the use of your title or your historical experience in that manner by anyone would be a violation of a use of office. The other allegations that she raised have to do with Mr. Burke's statement of economic interest. And specifically, she alleged that on his SEIs, in 1 year, he identifies the Western Liberty Network as a business under question 1. In the other year, he does not. But for the year it's identified as a business, the SEI changed in 23, and there are these additional questions you have to answer about any business that you list. Those questions are, you must identify the sources of income of the business if they contribute 10% or more of the business's annual income, and if those sources have a legislative or administrative interest in the public official, in his official, the filer in his official capacity. In this case, as I said, Richard Burke does list Western Liberty Group, Western Liberty Network as a business. Arguably, I don't believe it appears to even qualify as a business. He is a paid employee of the Western Liberty Network, but he is not a corporate officer from what we have been able to determine. Further, the source of income, David Elton and his foundations, that does provide income to Western Liberty Network, would not be required to be listed. Even if they produce more than 10% of Western Liberty Network's annual income, neither Mr. Elton nor his foundations are subject to the commission's jurisdiction. Therefore, they would not have a legislative or administrative interest and would not need to be listed. Thus, based on the information available, it does not appear that Richard Burke had a statutory conflict of interest or failed to disclose it, that he did not violate the prohibited use of office statute, and that his statement of economic interest was properly filed.
Thank you, Executive Director Myers. Before we allow Commissioner Burke to make a statement, any questions from commissioners of Executive Director Myers? Seeing and hearing none, Commissioner Burke, now is your time to make a statement.
Okay, thank you very much, Madam Chair. I first of all would like to thank Executive Director Myers for undertaking this investigation and handling it so professionally as I know all the staff does. I would also like to say to my fellow commissioners that I'm sorry that you have to deal with this. You know, when you try to be politically active as a member of the commissions, sometimes they can be rocky waters to navigate. And I've been doing my best to try and navigate those waters responsibly. Monica Kirk, the complainant in this case, my understanding was she was a very good friend of Claire Hall, and I have a lot of sympathy for that. You know, I see people like Claire Hall as political opponents, not personal enemies, and neither I or anyone else I know would have wished her death on her, and we all have sympathy for those left behind who knew her. And I also want to acknowledge that although she was, in my opinion, deficient in some areas, she did a lot of good work as well, particularly with regard to the homeless issue in Lincoln County. In the October meeting, I wasn't sure whether I should declare anything or not. I'm not an attorney, and although Director Myers and former Director Burson have explained it several times, I don't always get it right when I'm supposed to say something and when I'm not. And initially, I'm just weighing it over in my mind. Then we went into executive session, and then I said something, which I probably didn't have to say at all, but I said it in executive session. I should have said it before that. And maybe that's the genesis of all of this. So it's been an educational situation for me. You know, whatever you decide to do, you know, I know that all of you act in good faith, and all of you do your public duty properly. And so I'm very happy to leave it all in your hands. Thank you.
Thank you, Commissioner Burke. Commissioners, any questions for our respondent? Seeing and hearing none, I'll just make a comment. I want to thank our executive director for doing such a thorough job on this and being so professional. I do think that when we have our own commissioners come before the body, it's very important that we do a very thorough job and that we give a very thorough report and be transparent about these issues. So I just want to thank you for doing that. That's my only comment. Vice Chair, do you have a motion?
Thank you, Madam Chair. For executive session item number 12, I move the commission dismiss the complaint against Richard Burke.
Commissioners, you've heard the motion on executive session agenda item 12. Administrator, please call the roll.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Helt,
Aye.
Chair Payne.
Aye.
Motion passed 6-0 with 1 abstention.
Thank you very much. I'll try to stay out of trouble, everyone.
Thank you. Okay, we're going to move on to agenda item 13, and then we'll take a short break after this. Okay.
They should be in.
The phone? Okay. Ms. Smith-Reed, can you hear me? Star six to unmute yourself.
Yeah, hi, I'm sorry, I can hear you. I think. Can you hear me?
I can hear you. Thank you. My name is Shanoa Payne.
Yeah.
I'm the chair of the commission. The way this will happen. The way this will happen is that the investigator will give the report of your matter. Commissioners will have an opportunity to ask questions, if any. Then we will allow you to make a short statement, keeping in mind that the recommendation is to dismiss the matter before the commission today. So we ask that you keep it brief if you make any statement at all. And then we will vote on your matter. Okay?
Okay, perfect.
Okay.
Thank you, I understand.
Okay, thank you. Investigator Fenstermaker. Investigator Fenstermaker, please make your report.
Thank you, Chair Payne. Commissioners, this is Casey Fenstermaker for the record. Case number 26-169 ECF is a preliminary review report regarding Christine Smith-Reed, school board member of the Columbia County School District 502, also known as the St. Helens School District. With respect to this preliminary review, a complaint was filed alleging that Christine Smith-Reed may have used her office for financial gain when she discussed school board matters on social media. Based on the information in preliminary review, it appears Christine Smith-Reed submitted a public records request and used one of those records in the course of her discussion in a video on TikTok. Additionally, though she discussed these matters on TikTok, and she has an account that would allow her to be paid if she reached a certain number of views pursuant to TikTok's terms, it does not appear there was a financial gain, and she set the video to private to prevent the video from reaching the number of views that would or could result in payment. As a result, there does not appear to be a substantial objective basis to believe that a violation of ethics law may have occurred, and we're recommending dismissal in this case.
Thank you. Commissioners, any questions for our investigator? Okay, Ms. Smith-Reed, do you wish to make a statement?
I don't, I appreciate the time taken to investigate this matter.
Okay, thank you. Commissioners, any discussion? Vice Chair, do we have a motion?
Thank you, Madam Chair. For executive session agenda item number 13, I move that the commission dismiss the complaint against Christine Smith-Reed.
Thank you, Commissioners. You've heard the motion on executive session agenda item 13. Administrator, please call the roll.
Commissioner Helt,
We lose Commissioner Halt. We may have lost her.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mettler,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Chair Payne.
Aye.
Motion passed 6-0.
Okay, Commissioner Hell, I know you have to leave at some point. What is your time frame?
I'm trying to get out by 11:30.
11:30.
If you want, I can vote aye on that last motion as well. I got bumped out of the meeting for some reason.
Okay, thank you. Okay, I think what we'll do is we'll take a break and then we'll come back and we'll move back into public session briefly to vote on.
Just want to vote on it. Susan said we could vote on it.
No, it'll just take a few minutes. It'll take just a few
You don't
minutes.
have to read the script again.
Would I have to read the script?
Don't leave the meeting around for me. I can, if I'm needed, I'll stay. We don't need to do that.
I think we'll on it next.
Vote on it next month. Okay, we'll vote on it next month. Thank you for the reminder.
Just trying to save
do
you from
not-
having to read that
I do
again.
not want to read that again, so thank you very much. Okay, so we'll take a brief break and then we'll move back into executive session and proceed with the executive session agenda items 14 through 18. We'll take a 5-minute break. Thank you.
Chair, I'll try and stay as long as I'm needed.
Or just pause it. Just pause it.
I'll let the group.
We have our commissioners now.
Correspondence. Yeah. Whenever.
We have our commissioners back. See Commissioner Jancy. Do we have Commissioner Resendez Gutierrez, Commissioner Halsey? Maybe. I see Commissioner Burke. Commissioner Mettler, are you back?
Yes, I'm here. Sorry, I don't know if my camera is working or not.
Okay, great. Okay. So we are now proceeding to matters 14 through 17. We will hear matter 18 separately on the City of Shady Cove matters. And we have respondents Richardson, Knuckles, thank you. And we have the city administrator also present. And I just want to see if you can hear me. Ms. Knuckles, can you hear me? Star 6. Star 6 to unmute yourself. Ms. Knuckles, can you hear me?
Hello? Can you hear
Hello.
us?
Hi. Yeah, great.
Okay.
How about?
Sorry about that.
No, that's okay. I just wanted to make sure. And then Ms. Richardson, can you hear me?
Yes, I can. Thank you.
Okay. So I just want to kind of give you, I believe, so my name's Shanoa Payne. I'm the chair of the commission. And what's going to happen is we're going to get a report from the investigator, and then commissioners will have an opportunity to ask questions of the investigator. And then we will provide you and each of you an opportunity to make a statement. We will limit those statements to 3 minutes or less. And although the city administrator has been allowed to appear, we're not allowing the city administrator to make a statement, only the respondents. And so each of you will be allowed to make a 3-minute statement, and then we will allow commissioners an opportunity to ask questions of you should they have any. And then we will discuss the matter. Commissioners will discuss the matter, and then the decision that is being made is whether or not to move this to investigation. I want to clarify that there is no decision being made today as to whether a violation has actually occurred. It's an important clarification. That being said, Investigator Sullivan, please give the report.
Yes, thank you, Chair Payne and Commission. This is Investigator Josh Sullivan for the record. I'm presenting executive session agenda items number 14 through 17. This is a public meetings law complaint against the City Council for the City of Shady Cove. The complaint alleges that the City Council held a public workshop meeting on February 2nd, 2026 without providing a remote attendance option. The complaint alleges that it was reasonably possible for the City Council to provide a telephone, video, or other electronic or virtual attendance option for their meeting, and it states that the remote attendance options have been made available for other prior meetings. The information in this preliminary review indicates that due to limited staff and resources providing their standard Zoom access may have caused disruptions to normal City Hall operations. However, it also appears that it would have been possible to provide remote attendance options for the February 2nd meeting. There are other means that the City Council could have utilized to provide access to the general public, including telephone or other virtual means. In this case, it does not appear that the City Council made any attempt to provide members of the general public with telephone or other electronic access after it was requested. The information in this preliminary review appears to indicate that it may have been reasonably possible to provide those remote attendance options, but the City Council failed to do so or make any showing as to why providing any potentially available form of telephone or other access would not be reasonable. Thus, it appears that they may have violated ORS 192-670 sub 3 sub A. Additionally, the notice for the City Council's February 2nd meeting contained only one scheduled agenda item for discussion, and it appears that the list of topics may not have been specific enough to permit members of the public to recognize matters in which they were interested. And the meeting notice did not include an electronic link or telephone access information to allow members of the public to attend the meeting remotely. Thus, it appears that they may have violated ORS 192-640 sub 1. Based on the information available in this preliminary review, there appears to be a substantial objective basis to believe that the members of the City Council for the City of Shady Cove may have violated several provisions of public meetings law, and the recommendation is to move this case to investigation.
Thank you, Investigator Sullivan. Commissioners, any questions for the investigator? Seeing and hearing none. Let's start with Ms. Richardson. Now is the time for you to make a statement, and we just ask that you keep it to 3 minutes or less.
Okay. You want me to go? Okay, well, actually, could Councilor Knuckles start off?
Sure.
Okay.
Thank you. I'm Kathy Knuckles, and I testified before the commission in March and explained the turmoil here. So starting in October, we suspended and then terminated our city administrator, and we're now on our second interim administrator as we struggle to find a replacement, which God willing will happen next week. And through all of this, two vengeful friends of the dismissed administrator are taking advantage of our struggles and making our lives a living hell by microanalyzing our actions so that your organization can be used as a weapon against us. Before October, we didn't have any complaints. Now we're up to 8, all submitted by these same two ladies, plus the dismissed administrator. So the focus of this complaint is the absence of Zoom for a non-voting, no public participation workshop. And the report does acknowledge the severe disadvantages we operate with, and then states that perhaps we didn't try hard enough to find a solution. Well, we always, and I mean always, provide Zoom for all of our voting meetings, no matter the cost or the inconvenience. However, for non-voting, no public participation workshops, such as the one in the complaint, we did make a compromise decision that Zoom for these meetings will be provided, but not if it shuts down greater services to the public and not if it imposes additional costs that we can't afford. So for these workshops, the posted recordings or the minutes, they suffice. Our city has no other remote access means. Zoom is it. We don't have teleconferencing. Zoom is it. And we have no budget to buy other technology. And in fact, we have a huge budget shortfall that's forcing us to reduce our office staff from 3 down to 2, which will make our situation even worse. So the report says that we could use the Zoom system in the library, but a simple phone call to them would show that no system exists. So I'm sorry, but isn't this balance of services the very definition of reasonable? The agenda part of it, that one, if Josh listened to our recording, we talked about nothing else. It was just what was in the title of our workshops. That's how our workshops, they have one discussion item and that is it. So I think that one will just go away. If you live in a larger city, it's very easy to judge a rural, disadvantaged town through the big city glasses. And it would be really nice for us to have a city recorder and dedicated audiovisual meeting facilities. And it would be great if we had a conference center for offsite meetings, but we don't have these. And so we do the best with what we have, and we do believe we manage this in the spirit of the law. When I talked to Josh, he did admit that our case was subjective. So please look at our intent, our resources, and our dedication to the city as you interpret our reasonable actions. And if there is gray area here, please, by all means, give us some suggestions with a qualified dismissal. But please don't give these two vengeful people a guilty verdict that they can then parade around town, because we are doing our best here, our absolute best. So thank you very much for allowing me to speak.
Thank you, Ms. Nichols. Ms. Richardson, now it's time for you to make a statement.
Thank you. Shady Cove City Hall is located in a small building with the council chamber being the only area where meetings can be conducted. This space also serves as a work area for the contract planner, contract accountant, auditors, or anyone not working regularly at City Hall. Kathy shared a map and pictures with Josh showing him the space. There is one employee who's trained to conduct Zoom meetings. She's a planning technician who also works with the public when they come to the front desk. Perhaps because we have limited space and limited staff, our Zoom hosted meetings that allow public comment and decision making are held when City Hall is otherwise closed, an action that requires a staff member to likewise work extra hours. For non-decision informal workshops, we can't justify the overtime pay or the disruption of vital public and City Hall services. So we sometimes use the conference room of the Jackson County Library located next door. They do not provide Zoom equipment to host Zoom meetings. All they have is a limited bandwidth guest internet access, which has a history of unreliability. The Upper Road Community Center, located next to City Hall and the library, cannot depend on uninterrupted internet access, so they've scheduled no meetings by Zoom. But a significant issue that's not being addressed in this process is that the Oregon Government Ethics Commission is being used as a tool for political harassment of public officials who are working tirelessly to bring the city into compliance with vital staffing and financial issues and reliably conduct city business. In July of 2025, the former mayor and the city council president resigned in frustration with the city administrator, and I was appointed to the mayor position because of my background in accounting and finance. The remaining councilors hoped that I could restore financial reporting and get the city caught up on audits that lapsed after I left office in 2020. Shortly after I was appointed, it became clear that the city administrator's performance was a problem that needed addressing. Immediately, Councilor Wintry, City Administrator Michelle Perry, and the two ladies Kathy mentioned set out on a campaign to discredit me. One tool they used is the Ethics Commission complaints, and in the last 6 months, they have filed at least 8 complaints, 5 of which required a formal city response, 4 of which made it to the ethics investigations, and the remaining were missed for a procedural failure. Shady Cove City Council terminated Ms. Perry's employment on January 15th, 2026, at which time the harassment turned to retaliation. They are currently leading a recall campaign to have me removed from office. Your commission is being used as a tool to harass public officials who are working extremely hard to bring our city back from a financial crisis and move forward with recruitment of a competent city administrator.
Okay, thank you so much for that statement. Now is the time for commissioners to ask questions of the respondents. Should you have any? Not seeing any questions. I'll open it up to commissioners for discussion. Commissioner Halt.
Thank you, Chair. Is there any provisions in this for financial hardship? Because it sounds like if they have the staff member that can do the Zoom meetings, then they're going to have to pay overtime or pull her away from their duty already. So I'm wondering if the statute has any room for wiggle in there at all.
So this is Executive Director Myers. I would say what the statute provides is that to the extent reasonably possible, a public body, a governing body must provide electronic or telephone or digital access. In the past, that has been construed, for example, a fire district that is located in an area that does not actually have any internet access. It's not as if we would require them to pay, $20,000 to bring a line in. What the commission has held in other situations, though, is a city council who the only staff member who knew how to operate the equipment was absent on paid leave, and none of the council knew how to operate it. That was not held as reasonably possible not to provide the access. You can get the assistance of the League of Oregon Cities or SDAO or CIS insurance. I mean, you can ask for volunteers to help. You can learn how to operate the access. In a case like this, I understand the financial impacts. I guess one of my questions would be, do you have to hold the meeting at this time? Could the one employee flex her schedule so that you hold the meeting at 5 p.m.? I mean, it is up to the commission to make a determination of whether it was reasonably possible for the city council to provide public access. I think the statute does not distinguish the public's right to attend electronically based on whether it is a work session versus a meeting at which a vote will take place.
Thank you, Executive Director Myers. And I'm looking at the report, and it says that additional information would be needed to better understand whether the cost and inconvenience of providing Zoom access is too high, given the city's limited resources, or whether it would instead be reasonable to require the city to use remote attendance option that appears to be available to the city by using the city library. So my question, I guess, for the investigator is, if this were to proceed to investigation, what exactly, what information would be gathered to determine, that sort of reasonable access or reasonable possibility?
Yes, thank you for the question, Chair Payne. This is Investigator Josh Sullivan. One of the things that we would look into is which previous meetings have been held at the library. I know there's some conflicting reports on that. So in preliminary review, a couple different sources said that previous meetings were held in the library. They have that system set up there that's available for them to use. Also, what other options did they have? They are referring to this Zoom computer, but Zoom computer isn't the only option. There could have been telephonic or other ways to make it available, a remote option available. And in this case, there was a request for that, and it doesn't appear that an effort was made to do so. So just kind of looking at what options were available in the past and what they had used and what could be available.
Vice Chair.
This is not our first case with political implications, not even our first case today with political implications. But I'm struggling with 8 complaints. I mean, at some point, I mean, I think they're making an effort. Reasonable is up to our determination. I understand that. But I'm stuck on 8 complaints. At some point, this has gotten out of hand. So that's my struggle.
I I agree with Vice Chair's comments. And I think that the commission may need to look into issues around multiple complaints. But I still feel like that doesn't mean there isn't a reason to move this into investigation. I really struggle when the motivation behind a complaint is nefarious or politically motivated, but there's still validity to the complaint, or there's still it still meets the basis to move it to investigation. And I agree with you, Vice Chair, that it bothers me. I don't like that our commission gets used as a political tool. I don't find that that makes it an exception to our obligation when I guess there's a substantial basis to move it to investigation. And I do struggle with that. And I think that we could, as a commission, look at other ways to maybe curb those multiple complaints. And I think that's worth looking into. But I don't know that that's a basis to dismiss. And that's where I feel the struggle. Commissioner Jancy.
I agree with those comments. I would support the efforts you described. I would also just say, as concerning as it is, I think when we're in the context of when it's clear that there is a political dispute going on in a community, complaints about public access, I think, need to continue to be taken seriously. Those are exactly the moments where we need to make sure that public access is maintained. So I agree that the serial nature of the complaints is concerning, but I think our obligation is still to move forward with an investigation.
Thank you, Commissioner Jancy. Any other commissioners have comments? Commissioner Halt.
Thank you, Chair. I agree with all that's been said. I think it's so important to have access to meetings, and public access is the highest of priorities. I do empathize a lot with their space, their amount of employees, their equipment. And I'm wondering, I don't love the amount of complaints either. I think this is really a hard one. I'd like to ask if they've tried to use volunteers, because if they've exhausted all possibilities to get the meetings online, and it sounds like they have utilized, making sure it's a non-voting committee meeting versus they're trying to balance audits, which are more publicly important, to the committee meetings. So I'm just curious if there's a way, if they figured a way to rectify this in the future, because it doesn't sound like the library is a viable option from what was said. And so I'm just curious if there is if they've used volunteers, or if they have a way to fix it in the future. Thank you.
Ms. Knuckles or Ms. Richardson, would you like to respond to that question?
I'll take the first thing. First of all, for volunteers, the Zoom is on a city computer. We don't allow anyone from the public to access the city equipment, because that same workstation is the one that's used by our accountant and planning consultants. And so there is confidential information on there. So no, we don't. That is, so no, volunteers can't. I talked to Josh and he says, well, we could have used a cell phone. And I said, but I can't provide my cell phone number to the whole city. It can't conference these people in. And this woman made her complaint 2 hours before the meeting. That was a setup. That meeting notice was posted 4 days prior.
The other thing too, this is a small city and it's a retirement community. A lot of people just come here to retire. They don't want to be working for the city. They're just expecting the city to carry on their business as we need to, and that's what we've been trying to do. We actually have trouble getting enough people to volunteer for our planning commission. So it's a very small number of people who really step up and want things done. They just want it to work. And this group, their whole motivation is to punish us for doing the right thing in terminating the contract of our former city administrator.
And we did record the meeting, and it was posted in a timely manner. So the recording was there. It just, they couldn't watch us on Zoom or hear it live.
Yeah, there was a
Okay,
recording.
thank you. Okay, thank you. Other discussion from commissioners? Commissioner Halt.
Thank you, Chair. I really value having access to public meetings. I believe that this is a rural community that is trying their best, and I'm going to hope that they can get better at getting things out there in time and in a live version. But I'm going to vote against a motion to move this forward for investigation, because I feel like we need to. I personally need to say this can't be political. Thank you.
Okay, thank you, Commissioner Halt. Vice Chair, I don't know where you are on this. I still feel like I want to move this to investigation. So I'm comfortable making the motion if you are not.
Oh, no, I can do it. Before I make the motion, I'm gonna vote to move this forward because I think there are some questions we need to answer, but I'm also gonna state very clearly that my tolerance for this commission being used by some people in this community is wearing quite thin. So
I agree and appreciate those comments, and I do think maybe we could schedule a work session or something along those lines to a public work session or something along those lines to further discuss this issue, to see if we can tackle that head on as a commission, because I do believe that's something that we should address.
thank you. Okay. I move the commission find there is a substantial objective basis for believing that Lena Richardson may have violated ORS 192-640 sub 1, ORS 192-670 sub 3, and OAR 199-050-0040 sub 3, and the commission should investigate accordingly.
Commissioners, heard the motion on executive session agenda item 14. Administrator, please call the roll.
Commissioner Halt,
Nay.
Commissioner Mettler, Commissioner Mettler.
Aye.
Thank you. Commissioner Jancy,
Aye.
Commissioner Burke,
Nay.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Thompson.
Aye.
Chair Payne.
Aye.
Motion passed 5-2.
Vice Chair.
Thank you, Madam Chair. I move the commission find there's a substantial objective basis for believing that Steve Mitchell may have violated ORS 192-640 sub 1, ORS 192-670 sub 3, and OAR 199-050-0040 sub 3, and that the commission should investigate accordingly.
Commissioners, you've heard the motion on executive session agenda item 15. Administrator, please call the roll.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Burke,
Nay.
Commissioner Thompson,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mettler,
Aye.
Commissioner Halt,
Nay.
Chair Payne.
Aye.
Motion passed 5-2.
Vice Chair, item 16, please.
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Kathy Knuckles may have violated ORS 192-640 sub 1, ORS 192-670 sub 3, and OAR 199-050-0040 sub 3, and that the commission should investigate accordingly.
Commissioners, you've heard the motion on number 16. Administrator, please call the roll.
Commissioner Burke,
Nay?
Commissioner Resendez Gutierrez,
Aye.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Thompson,
Aye.
Commissioner Helt,
Nay.
Chair Payne.
Aye.
Motion passed 5-2.
Vice Chair, item 17, please.
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Jeffrey Vanier may have violated ORS 192-640 sub 1, ORS 192-670 sub 3, and OAR 199-050-0040 sub 3, and that the commission should investigate accordingly.
Commissioners, you've heard the motion on executive session agenda item 17. Administrator, please call the roll.
Commissioner Thompson,
Aye.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Burke,
Nay?
Commissioner Helt,
Nay.
Commissioner Resendez Gutierrez,
Aye.
Chair Payne.
Aye.
Motion passed 5-2.
Ms. Knuckles and Ms. Richardson, we have moved these matters to investigation. No vote has been made that any violation has occurred. We're simply seeking more information. Staff will be in touch with you about next steps. As you also heard, the commission does have grave concerns about these type of politically motivated and multiple complaints, and we'll be looking into ways to potentially curb these types of politically motivated and multiple complaints.
Okay. All right. Thank you. Thank you very much.
Okay, we also have one more City of Shady Cove matter, matter number 18, not appearing. So do we need to hear the report again? Nope. Okay, so we just need to vote on that separately.
Yes.
Okay. Okay, can we get a motion on number 18?
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Paige Winfrey may have violated ORS 192-640 sub 1, ORS 192-670 sub 3, and OAR 199-050-0040 sub 3, and that the commission should investigate accordingly.
Okay, commissioners, you've heard the motion on executive session agenda item 18. Administrator, please call the roll.
Commissioner Jancy,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Burke,
Aye.
Commissioner Mettler,
Aye.
Commissioner Thompson,
Aye.
Commissioner Helt,
Nay.
Chair Payne.
Aye.
Motion passed 6-1.
She is on.
She's
Yes. She's on and has full permissions.
Ms. Chisholm, can you hear me?
Yes.
Okay, am I saying your last name correctly?
Yes.
Okay, all right, great. My name's Shanoa Payne. I'm the current chair of the Ethics Commission. And the way this is going to occur is that the investigator will give a report of the preliminary review. And then commissioners will ask questions of the investigator if they have any. And then we will give you an opportunity to make a statement. Because of our long agenda today, we will ask you to limit that statement to 3 minutes or less. Then the commissioners will have an opportunity to ask questions of you, should they have any. And then we will move to open the floor for commissioners to discuss the matter. And then we will move to a vote. And the only decision being made today is whether or not to move this matter to investigation. I just want to clarify that there is no decision being made today as to whether any violations actually occurred.
Understood.
That being said, Investigator Pacheco, please give the report.
Thank you, Chair Payne and Commissioners. This is Investigator Daniel Pacheco for the record. Agenda items 19 through 23 in your meeting books are preliminary review reports from members of the Oregon Trail Academy School District Board of Directors. The complaint in this matter arises from meetings to address allegations of misconduct against the school district director. As a result, the board convened 3 public meetings: a January 22nd special meeting with an executive session, a January 27th special meeting to discuss the matters discussed on January 22nd, and which included a vote to place the director on paid administrative leave and hire a third-party investigator, and a February 17th regular meeting at which the board discussed and addressed parent and community concerns. Based on the information gathered in this preliminary review, it appears that the board complied with the provisions in public meetings law at the January 22nd, 27th, and February 17th public meetings. However, it does not appear that they did so at the January 22nd executive session meeting. ORS 192.660 subsection 2B permits public officials to consider permits members of a public body to consider the dismissal of or disciplining of, or to hear complaints or charges brought against a public officer, employee, staff member, or individual agent who does not request an open hearing. In her response to commission staff, Board President Chisholm explained that the purpose of the executive session was to hear and discuss complaints/issues that parents and students had raised concerning the district director. While the executive session minutes provide that some of the discussion topics may have been proper, it is unclear whether the complaints that were reviewed in executive session also included allegations related to the director's training and improper release of confidential information. If these cases move to investigation, commission staff would seek to obtain further information of the allegations included in the complaint against the school district director and determine whether the discussions were authorized or unrelated, such that the board members violated ORS 192.660 sub 2B at the January 22nd executive session meeting. Consequently, the recommendation in the preliminary review reports is to move these cases to investigation to determine if the school district board of directors violated ORS 192.660 sub 2. Thank you.
Thank you, Investigator Pacheco. First, commissioners, any questions for our investigator? Seeing and hearing none. Ms. Chisholm, now is the opportunity for you to make a statement. And again, we just remind you that your time limit will be 3 minutes. Thank you.
Okay, thank you very much. I just want to start by saying thank you for allowing me to speak this morning. I am the board chair for Oregon Trail Academy, which is a public charter school sponsored by the Oregon Trail School District. I want to start by giving a small bit of background on this situation. The school is in turmoil right now, and these constant complaints are a small part of the attack of a group of parents has undertaken against the board. Unfortunately, the board was alerted to an issue with the director and how a serious complaint against a staff member was handled, which started this process. The director has been on paid leave and has now been told her contract will not be renewed. This is not the outcome this group wants, and they're actively working to remove this board and replace with a board that will bring her back. Board members have been verbally attacked. They've gone after us on social media, attacking both our character and our businesses. We went from 1 to 2 guests at any given board meeting to close to 100 at each meeting during this process. During these meetings, parents have screamed, threatened, and chosen not to follow the rules. I personally have experienced parents at my house, have experienced fear for my family. The only reason this board is still volunteering, despite the barrage of attacks, is that we all agree the students' safety and education are the most important, and we need to get through the current situation, get the school on track, and move forward and honor our commitment. This is no longer a healthy, productive environment with board members being shown zero respect. All board members plan to leave this summer, preferably by June 30th. And it is an untenable situation with the abuse and bullying. The parent group has chosen to weaponize this process using this commission as their tool, not with concern for the students, but to win a battle of wills. We take our jobs very seriously and do our best to follow every rule. As a public charter, we've had no staff support for the board. During the January 22nd executive session, which was referenced as ORS 192660, we heard from a student and parents about their concerns with the director's conduct. We also heard alarming information from the district about missing or incomplete reports with potential consequences of significant financial liability. Testimony included concerns about confidentiality, mandatory reporting, retaliation, personnel, and professional conduct. After hearing concerns, the board had conversations about the severity of the situation. At one point, board member Curtis asked the question if certain elements of the concern could be rectified with training in lieu of disciplinary action or dismissal, or was this an education or personality issue? This was discussed as part of a larger conversation. I really feel like this was part of the intent of that rule. And I apologize, I ran over.
That's okay. Thank you so much. Commissioners, any questions for Ms. Chisholm? Vice Chair.
Ms. Chisholm, the question was asked, was there discussion afterwards? Did somebody say we can't talk about this now? I mean, kind of what happened after the question was asked?
So the question was asked whether how this came about, and we decided that there were no decisions made. We decided this was a huge amount of information that we should look at, and we moved forward with reconvening on the 27th.
Okay. Thank you.
Mm-hmm.
Any other questions for the respondent from commissioners? Any discussion? Vice Chair, you have comments?
I'm just not sure I see enough here to keep going. I feel like this was a question asked. They essentially, my words, not theirs, decided to take it up at another meeting. They took it up at 2 more meetings that were properly noticed. I don't see it there.
Yeah, I'm sort of leaning towards dismissal as well. Commissioners have any thoughts on this? Commissioner Halt?
I support dismissal as well.
Okay. Vice Chair, you have a motion?
I do. Thank you, Madam Chair. For agenda item number 19, I move the commission dismiss the case against Shannon Chisholm.
Okay, commissioners, you've heard the motion on executive session agenda 19. Administrator, please call the roll.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Helt,
Aye.
Commissioner Burke,
Aye.
Chair Payne.
Aye.
Motion passed 7-0.
There's the PML dismissal. You could combine.
Oh, we could do them all together.
Oh, they're not appearing?
No, the others are not
Oh,
appearing.
I didn't know that. So,
Okay, we'll do the rest all together.
Okay.
Ms. Chisholm, thank you so much for appearing. The matter against you has been dismissed.
I appreciate that very much, and I appreciate your help. Thank you.
Thanks. Okay, we can do it.
All right. Yeah, I just didn't know they were not all of them. I thought they were appearing separately. So
no, that's okay.
All right, here we go. For agenda items number 20, 21, 22, and 23 on our executive session calendar, I move the commission dismiss the complaints against Amy Curtis, Mark Ramsey, Katrina Ramsey Muir, and Heather Lara.
Okay, commissioners, you've heard the motion on items 20 through 23. Administrator, please call the roll.
Commissioner Helt,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mettler,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Chair Payne.
Aye.
Motion passed 7-0.
Okay, we're going to start with skip ahead to agenda item 27. Okay, Ms. DeGraff, can you hear me?
Yes, I can hear you just fine. Can you
Am
hear
I
me?
saying, yes, am I saying your last name correctly, DeGraff?
Yes, that's good. Thanks.
Okay, my name is Shanoa Payne. I'm the chair of the Ethics Commission, and I just want to kind of set out how this is going to occur. First, the investigator will give the report of the preliminary review. And then following the report, the commissioners will have an opportunity to ask questions of the investigator. Following that, you will be given a short period of time to make a statement, and we ask that you keep that statement to 3 minutes or less. Following your statement, commissioners will have an opportunity to ask questions of you, should they have any. And then the floor will open up for commissioners to discuss the matter. And then commissioners will vote. The recommendation is to move this to investigation. The only decision being made today is whether or not to move this matter to investigation. There is no decision being made today as to whether any violations actually occurred. I just want that to be very clear. That being said, the investigator will now give the report. Investigator Patterson.
Thank you, Chair Payne and Commissioners. This is Investigator Silas Patterson for the record. I am presenting executive session agenda item 27 in your meeting books. This is a public meetings law complaint against members of the Lane County School District's Board of Directors, also referred to as the Springfield School District or Springfield Public Schools. The complaint alleges that prior to the district's board meeting on February 20th, 2026, several board members engaged in prohibited serial communications and violated other provisions of public meetings law. In this case, it appears that a quorum of the board met in private and communicated with each other outside of a public meeting about the decision to fill the vacant superintendent position with an acting superintendent and the process for selecting the acting superintendent. It also appears that these series of communications likely constituted a meeting that was not properly noticed or documented through recording or meeting minutes. Based on the information in this preliminary review, there appears to be a substantial objective basis for believing that members of the Lane County School Board of Directors may have violated various provisions of public meetings law. The recommendation in your books is to move this case to investigation.
Thank you, Investigator Patterson. Commissioners, any questions for the investigator? Seeing and hearing none, Ms. DeGraff, now is the opportunity for you to make a statement, and just a reminder to keep that statement to 3 minutes or less.
Okay. Thank you. Chair Payne and Commissioners, thank you for the opportunity to speak today. I come before you with humility, and I know it's probably odd that I'm a complainant and a respondent. I feel like if I had repeatedly raised concerns about processes and governance transparency. I feel like if I would have known I was going to be sitting here in this position, I would still have filed a complaint. And I know I'm not above the law. If I make mistakes, I definitely am going to own them. And I think accountability should apply equally, especially for a public institution like our school board. But I do hope the commission considers the reality facing individual board members. It's kind of hard to figure out how an individual board members can participate in urgent matters, repeatedly raise questions and fulfill my duty when there's a broader process being used by others. You know, how to comply with the law when there's other board members that are doing things that are frustrating to me when I repeatedly ask criteria. Has that been established for the process? I raised questions throughout this whole thing of whether or not interview questions were developed, how candidates were identified. I have emails from before the public meetings on, hey, are we going to have this public meeting? We need to just set the criteria and set a timeline and everything. So I know that irony is difficult to ignore. The legislature has recognized the failures of governance and that it has serious consequences. And I know you guys know about the superintendent's protections because sometimes board members don't always follow the process. So right before this, our own district's history, prior serial communications and governance failures contributed to a superintendent's departure and a costly settlement. That was just weeks before. So I don't want to relitigate those events or claim intent. I just say those issues matter and it affects public trust. The only thing I knowingly did was submit interview questions individually when asked. They weren't developed through discussions with other board members, and I didn't seek feedback. I didn't seek consensus, and I didn't attempt to persuade others toward a particular outcome. Actually, I submitted those questions based on our existing board policy CBA that were qualifications of a superintendent. Because the board hadn't set criteria, I wanted to follow some process. And I even stated that during the public process that was the basis for my questions. I wasn't trying to hide anything. I just openly explained it on record. So my consistent role through this process was to ask questions and raise concerns about the process. And I even took the training when this new law came about in 2025 January. I took the training again with the other board members at the OSBA conference in August. So I have taken those new laws seriously. Is my time up?
Yeah, it is, but you can finish wrapping up.
I just want you to consider the whole context, and I really I respect the work you do, and just realize I know that there's fairness and nuances, and that it is a difficult position to be an individual person in a board. But thank you for your time.
Thank you for that statement. Commissioners, any questions for our respondent? Vice Chair.
You, Mr. Graff, when you had these communications with the board chair, did he ever ask you how you plan to vote? Did he ever communicate how any other board members plan to vote? I'm trying to get at, was there an was he sharing information, or was he telling you we have this many votes? How are you going to vote? So that's what I'm trying to differentiate between.
Yeah, for me, I didn't answer the phone calls. I had expressed things in writing that I didn't hear back on. I would just hear, or I'd see an email to other board members as we discussed, or he would say, I've spoken to other board members on my voicemail, but he never actually responded to my emails asking, when are we going to do this publicly? And then the next thing I know, there's this meeting set for all these candidates that I wasn't aware of. So no, he didn't ask me how I was going to vote, and I don't know if he would have. I didn't answer.
Okay, thank you.
Mm-hmm.
I have a question. I have a question for our maybe Executive Director Myers or maybe our legal counsel. Would submitting interview questions be considered, could that be considered purely factual, or is that, I mean, I guess I'm struggling with like interview questions being purely factual versus part of the decision-making process.
Right. So the question is, would it fall under that exception in 690, or is submitting and sharing what questions they are, does that then shape the criteria and considerations of the board in how it's going to select? Does it frame the deliberations essentially? Because the determination of what questions will be asked is going to therefore determine what information will be provided. in the interviews. So to that extent, having discussion or sharing communications about the questions would appear to constitute part of the deliberation process.
Yeah. I think we need some more information.
Yeah.
About this. I mean, I think we don't have enough information to make a decision about what we know discussions took place. Some of those discussions may be okay, some of them might not be okay, but I just don't feel like we know enough about the substance of those discussions, especially as it relates to other board members, to know if a quorum was discussing something they shouldn't have been.
Yeah, I agree. Okay. Vice Chair, are you prepared to make a motion?
Chair, can I interrupt for a moment, please?
Oh, yes. Sorry. We are going to wait to vote until we hear all the other matters. Thank you for that nudge. So, Ms. DeGraff, we need to hear from all the other respondents on this matter before we vote on your matter. So we are going to have you leave the room again, and then
you'll have to rejoin.
You'll rejoin and go into the waiting room, and then we will, how does this happen?
We'll let you back in once we come back to vote on your particular case.
Yeah, so leave and rejoin, and we'll put you back in the waiting room.
Okay, thank you.
Thank you so much.
Yeah.
I knew that, and yeah. Okay, so
The other two are here. I'm going to let them in right now.
And then 24 is not appearing.
Okay.
Hi.
Hello, Ms. Langworthy and Mr. Cole. Can you hear me?
I can hear you. Yes.
Yeah, I can see you. Mr. Cole, are you on?
Yes, I am. Hello.
Okay, great. My name is Shanoa Payne. I'm the chair of the Ethics Commission. So the way this will work is the investigator will give the report of the preliminary review, and commissioners will have an opportunity to ask questions of the investigator should they have any. And then we will allow each of you to make a short statement should you choose to do so. We will limit that statement to 3 minutes each, just because we have a long agenda today. And then we will open it up to allow commissioners to ask any questions of each of you should they have any. And then we will proceed to discussion and a vote on whether or not to move this to investigation. The only decision before the commission today is whether or not to move this to investigation. There is no decision as to whether any violations have actually occurred. I just want to make that distinction. That being said, Investigator Patterson, please proceed with your report.
Thank you, Chair Payne and Commissioners. This is Investigator Silas Patterson for the record. I am presenting executive session agenda items 24 through 26 in your meeting books. This is a public meetings law complaint against the Board of Directors for the Lane County School District, also referred to as the Springfield School District or Springfield Public Schools. The complaint alleges that prior to the district's board meeting on February 20th, 2026, several board members engaged in prohibited serial communications and violated other provisions of public meetings law. In this case, it appears that a quorum of the board met in private and communicated with each other outside of a public meeting about the decision to fill the vacant superintendent position with an acting superintendent and the process for selecting the acting superintendent. It also appears that these series of communications likely constituted a meeting that was not properly noticed or documented through recordings or meeting minutes. Based on the information in this preliminary review, there appears to be a substantial objective basis for believing that the district board members may have violated various provisions of public meetings law. The recommendation in your books is to move this case to investigation.
Thank you, Investigator Patterson. Commissioners, any questions for the investigator? Seeing and hearing none, which of you would like to proceed first with your statement? Ms. Langworthy or Mr. Cole?
I didn't have a statement prepared, so I will just say that, yeah, it wasn't clear. I'm working to better understand public meetings law, and it's seems challenging coming in as a volunteer to understand the breadth of rules and laws that all play in the part in governance. So that's about all I have to say.
Thank you, Mr. Cole, for that. Ms. Langworthy, am I saying your last name correctly? And you're on mute right now. There's a little microphone. There you go.
Okay. Sorry about that. Yeah, I will say that there has been an enormous amount of speculation without question or conversation. Jonathan Light was acting within his role as chair and following legal advice from Rebecca. I had sent 24 emails your guys' way. I'm sorry for the lateness of it, and it was sent this morning, showing his emails that he sent out. We were told by December 8th that Todd Hamilton was put a tort claim against us. In January, he departed. And we also had a board member depart as well, the chair. And we had to expedite many things and all at once. And I believe that we stayed, especially within direct contact, very close with the board attorney, where she has concluded that we had acted within reason to, within our boundaries. Especially since there isn't any policy regarding a policy around like an acting superintendent. So yeah, this has been very, very, very frustrating for us. Again, there was no meeting outside. There was no to what I understand and how I understand it, we didn't have serial communication, and that's my interpretation, of course. But
thank you, Ms. Langworthy. Commissioners, any questions for our respondents?
Sure.
Vice Chair.
I think we need to move this forward and get some more information. I appreciate Ms. Langworthy sending those emails over this morning. Just for our investigator, I'd kind of like to, if he hasn't already considered it, I'd like to see kind of what the advice they got from their attorney was, if that can be shared, because I know that has an effect on the penalty matrix should we decide there's a penalty here. So I think there's a lot of things we need more answers to, and I think this case would benefit from moving forward to take a look at those things.
Thank you, Vice Chair. Those are excellent comments, and I concur. It sounds like we would benefit from looking at the emails that you sent and any advice from counsel. So I concur with Vice Chair's comments. Any other comments or discussion from commissioners? Okay, Vice Chair, do you have a motion right now? We would be looking at 24 through 26. Do you have a motion on 24?
I think I can move these three together, can I not?
No,
I cannot.
it's individual when it's moved to investigate.
Okay. All right. Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Jonathan Light may have violated ORS 192630, ORS 192640, ORS 192650, OAR 199-050-0015, and OAR 199-050-0020, and that the commission should investigate accordingly.
Thank you, Vice Chair. Commissioners, you've heard the motion on agenda item 24. Administrator, please call the roll.
Commissioner Thompson,
Aye.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Burke,
Aye.
Commissioner Helt,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Chair Payne.
Aye.
Motion passed 7-0.
Vice Chair, item 25, please.
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Amber Langworthy may have violated ORS 192-630, ORS 192-640, ORS 192-650, OAR 199-050-0015, and OAR 199-050-0020, and the commission should investigate accordingly.
Thank you, Vice Chair. Commissioners, you've heard the motion on agenda item 25. Administrator, please call the roll.
Commissioner Jancy,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Burke,
Aye.
Commissioner Mettler,
Aye.
Commissioner Thompson,
Aye.
Commissioner Helt,
Aye.
Chair Payne.
Aye.
Motion passed 7-0.
Vice Chair, item 26, please.
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Ken Cole may have violated ORS 192-630, ORS 192-640, ORS 192-650, OAR 199-050-0015, and OAR 199-050-0020, and that the commission should investigate accordingly.
Thank you, Vice Chair. Commissioners, you've heard the motion on agenda item 26. Administrator, please call the roll.
Commissioner Mettler,
Aye.
Commissioner Jancy,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Helt,
Aye.
Commissioner Burke,
Aye.
Chair Payne.
Aye.
Motion passed 7-0.
Ms. Langworthy and Mr. Cole, thank you for appearing today. The commission has moved your cases to investigation. Again, no decision was made today that any violations have occurred. We simply need more information. Staff will be in touch about next steps. Thank you.
Thank you.
Bring in Nicole. She's saying I should have permission.
Okay, Ms. DeGraff, welcome back. Now is the time for commissioners to, can you still hear me? We had her in the.
She's still.
Oh, okay. Ms. DeGraff, can you hear me?
Yes, I can.
Okay, now is the time for the commission to make a decision on your matter. We've heard from all respondents, so we're going to move forward on making a motion on, first we'll open it up for any discussion from commissioners, and then we'll move to a vote. So first, is there any discussion from commissioners on this matter? I will just say that I do think we could benefit from more information. We did receive some additional material just this morning. I guess a lot of emails, and I think we would benefit from reviewing those emails and then also potentially advice from counsel. I think this is something that I think we need more information on. So I think we would benefit from moving this to investigation and looking at all that information.
Okay.
Other commissioners have comments? Vice Chair, can we have a motion?
Thank you, Madam Chair. I move the commission find there is a substantial objective basis for believing that Nicole DeGraff may have violated ORS 192.630, ORS 192.640, ORS 192.650, OAR 199.050.0015, and OAR 199.050.0020, and that the commission should investigate accordingly.
Thank you, Vice Chair. Commissioners, you've heard the motion on agenda item 27. Administrator, please call the roll.
Commissioner Halt,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mettler,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Chair Payne.
Aye.
Motion passed 7-0.
Thank you, Ms. DeGraff. What the commission has just done, as you've heard, is move this matter to investigation. No decision has been made that any violations have occurred. Staff will be in touch with you about next steps.
Okay, thank you.
Thank you for appearing today.
Bye.
I think we'll try to get through the rest of the executive session, and then we'll take a break for lunch before going to the public session agenda. So let's move on to number 28. Investigator Patterson, please provide the report.
Thank you, Chair Payne and Commissioners. This is Investigator Silas Patterson for the record. I'm presenting executive session agenda item 28 in your meeting books. This is a public meetings law complaint against members of the Lane County School District's Board of Directors, specifically involving Mr. Brew. He was not appointed to the Lane County School Board until March 9th. Therefore, he was not a member of the board during the period relative to this review. The recommendation in your books is to dismiss this case.
Thank you, Investigator Patterson. Commissioners, any questions for the investigator? Seeing and hearing none, Vice Chair, can we get a motion?
Thank you, Madam Chair. For executive session agenda item number 28, I move the commission dismiss the complaint against Robert Brew.
Commissioners, you've heard the motion on item 28. Administrator, please call the roll.
Commissioner Halt, did we lose Commissioner Halt?
She had to leave, so she may not be with us anymore.
Thank you. Commissioner Mettler, Commissioner Mettler,
Sorry, it dropped me out of the meeting for a minute. Can you, I missed, I was out, so.
This is executive session agenda item 28, and it's a motion to dismiss.
Aye.
thank you. Commissioner Jancy,
Aye.
Commissioner Burke,
Aye.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Thompson,
Aye.
Chair Payne.
Aye.
Motion passed 6-0.
Thank you. We'll move on to executive session agenda items 29 through 33, which we can all hear together. Investigator Patterson.
Thank you, Chair Payne and Commissioners. This is Investigator Silas Patterson for the record. I'm presenting executive session agenda items 29 through 33 in your meeting books. This is a public meetings law complaint against members of the Lakeview Town Council. The complaint alleges that members of the Lakeview Town Council may have violated Oregon public meetings law when considering matters not posted on their January 27th, 2026 meeting agenda, and also alleges that members of the council engaged in secret deliberations to select planning commission members via a non-public process. Based on the information in this preliminary review, it appears that the grievance was filed outside of the 30-day filing requirement as defined in ORS 192.705 sub 1 and OAR 199.050.070 sub 2. In this case, it appears that the appointment of planning commission members occurred during a meeting on January 13th, 2026. Therefore, the statutory deadline to file a grievance was February 12th, 2026. The grievance was not filed until February 25th. The recommendation in this case is to dismiss.
Thank you, Investigator Patterson. Any questions for the investigator? Seeing and hearing none, we can have a motion on all of these together, Vice Chair.
Thank you, Madam Chair. For executive session agenda items number 29, 30, 31, and 32 and 33, I move the commission dismiss the complaints against Kevin Sims, Marty Collins, Jessica Calvin, Charlie Tracy, and Andrea Wishart.
Commissioners, you've heard the motions on executive session agenda items 29 through 33. Administrator, please call the roll.
Commissioner Resendez Gutierrez,
Aye.
Commissioner Burke,
Aye.
Commissioner Thompson,
Aye.
Commissioner Jancy,
Aye.
Commissioner Mettler,
Aye.
Chair Payne.
Aye.
Motion passed 6-0.
Okay, we will end the executive session. We'll break for lunch. We'll reconvene at 12:30 and go open to move to our public session agenda. Right.
Hmm.